Hello guys, what's up? I'm Little Ryan with you. Today I introduce of you Houston Maritime Attorneys. We serve injured maritime workers nationwide, offices in Texas and Louisiana. Just like any other industry, seamen are at the risk for suffering work-related injuries anytime they are on the clock. The courts recognize this and are continually working to protect injurious seamen through general maritime law. Maritime law gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any suffering of medical complications. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law's roots can be tracked back to the unwritten customs of nautical behavior of the Egyptians and Greeks. However, the earliest formal codes were established around 900 BC on the Greek island of Rhodes. The original maritime laws and codes stemmed from the accident customs and rules of shipping. For example, the doctrine of general leverage, the concept that all sea cargo stakeholders such as owner, shippers, etc. evenly share any damage or losses that may occur as a result of a voluntary sacrifice of parts of the vessel or cargo to save the whole can be tracked back to the early shipping customs of the Rhodians. The concept of a separate legal authority regulating maritime issues was brought to the West by Eleanor of Aquitaine, who learned of the concept when she accompanied her first husband, King Louis of France to the Mediterranean of the Second Crusade. The terms Admiralty law came from the British Admiralty courts, who presided over maritime matters separately from England's common law courts. As the US judicial system is based on the British system, amended Admiralty laws were gradually incorporated into our legal system soon after the Constitution was ratified. When does maritime law apply? Perhaps most obviously, maritime law applies to events that occur on high seas. In other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial sea, which are waters within 12 miles of the shore. However, the law's applicability becomes less clear further island early in the United States history. Maritime law did not apply to incidents that occurred within the body of the country and therefore excluded incidents involving the Great Lakes and Nantial Island waterways. However, throughout the 9th century, this exclusion eroded away. Maritime law is now applied to navigable waters. A waterway is deemed navigable if by itself or by uniting with other waters. It can serve as a continued highway over which commerce is or may be carried on with other states for foreign countries. Consequently, if a body of water is completely landlocked within a single state, then it is not navigable for purpose of admiralty jurisdictions. However, a body of water does not need to flow between states to be deemed navigable. A body of water may be deemed navigable if it is a link in a chain of bodies of water that can be used to serve interest, commerce. Ultimately, the test is that commerce of one state must be capable of being carried into another state or a foreign country. Once this test has been passed, it is likely that maritime law will be applicable even if it is a recreational vessel. Incidents that require Texas maritime accident attorneys. Houston Maritime's injury attorneys exist to help injured seamen or dock workers get the compensation they need to recover from serious injuries and afford long-term medical costs that occurred offshore. That includes any accidents that occur on navigable waters such as rivers and ocean and in the harbors or docks.